Chairman Biggs, Ranking Member Jackson Lee, and members of the committee, thank you for the opportunity to testify before you today. As a former federal prosecutor and former U.S. attorney and now executive director of Right on Crime, I am concerned about DOJ, including their vision of clemency. Thomas Jefferson wrote, "The most sacred of the duties of government is to do equal and impartial justice to all its citizens. Philippus Formis deserves no less." Yet DOJ appears determined to deny Mr. Formis that justice, which is supposed to be the bedrock of the American legal system. DOJ's unflinching decision to retry Mr. Formis on the open counts betrays its prior representations to the court, nullifies a presidential grant of clemency, and what should concern us all is nakedly vindictive. This complete disregard for our core constitutional principles cannot and should not be tolerated. Before we can fully capture the extent of the problems with DOJ's unreasonably dogged pursuit of Mr. Formis, we must first acknowledge how rare and precious executive clemency has become at the federal level. In recent decades, presidents have typically granted some form of clemency to no more than a couple hundred individuals over the course of an entire presidential term. President Biden, for his part, outside of his dramatic but largely empty announcement on marijuana convictions, has granted a mere 120 petitions in his first 2.5 years in office, most of whom were already out of prison. Small in absolute terms, these clemency actions are positively minuscule compared to the volume of petitions for clemency the executive branch receives. As of this month, for example, there are 16,933 pending clemency petitions. One look at the current clemency process, decades in the making and reinforced by President Biden, and it's not difficult to see why clemency has nearly disappeared. In short, our leaders have forgotten Alexander Hamilton's own observation that humanity and good policy conspire to dictate that the benign prerogative of pardoning should be as little as possible fettered or embarrassed, and instead allowed clemency to be controlled in large part by DOJ. The very same DOJ so dismissive of clemency and eager to undercut it in Mr. Formis' case. Individuals seeking clemency must send their petitions first to DOJ, the same government agency responsible for their convictions. It's a system with a strong structural bias against clemency that practically begs of conflict of interest. It is an awesome power and rightfully among the relatively few authorities explicitly enumerated in the Constitution. Unfortunately, the fact of Mr. Formis' saga revealed DOJ has lost sight of its founding mission and is willing to take any steps and push past legal and ethical boundaries to get what it wants. In 2016, Philippus Formis was tried by a jury which found him guilty of 20 counts. The jury did not reach a decision on an additional 6 counts and did not convict him on healthcare fraud conspiracy. At Mr. Formis' 2019 sentencing, even though he was acquitted of 2 counts of healthcare fraud and the jury could not reach a verdict as to the healthcare fraud conspiracy, the judge sentenced Mr. Formis as though he had been convicted. On the 20 counts of conviction as found by the jury, he would have been facing 5 years in prison. At DOJ's insistence, the judge considered the acquitted conduct and the unadjudicated healthcare fraud conspiracy charge and increased Mr. Formis' sentence to 15 years, imposing a 20-year sentence. After DOJ suggested the retrial of 6 unadjudicated counts was an option, the judge said, "I think I announced at the time of sentencing that in imposing the sentence, I considered the healthcare fraud conspiracy conduct and 5 undecided counts. So I don't know what more DOJ is going to get out of the case and the additional counts." Ultimately, on December 22nd, after spending almost 5 years in prison, President Trump commuted his sentence. A few months after the clemency warrant was issued, DOJ announced its decision, despite having committed to not continue to prosecute Mr. Formis in open court, that they would continue to prosecute him on the open counts. The government is intent on retrying Mr. Formis on counts based on conduct that formed the basis of his 20-year sentence, which was commuted. Another fundamental and equally compelling concept of our criminal justice system is the double jeopardy clause of the U.S. Constitution, which provides that no person shall be subject to the same offense or be twice put in jeopardy of life or limb. Any retrial of Mr. Formis appears violative of the presidential commutation and the double jeopardy clause. Recent events, however, clearly show that for the right defendant, the son of the current president, for example, DOJ is willing to allow a person to move on with their lives. The legitimacy of the entire criminal justice system suffers in the face of such disparate treatment where a second chance appears granted based more on who a person is rather than what they have done. Thank you.
Thank you. We appreciate